Jefferson County Court at Law number 2 is now in session. The court is in session with the court's trial docket. Let's see. First case is cause number M332608 and cause number M332610. Both cases are styled the state of Texas versus a sudden surprise Stevens. Ms. Stevens is present, and she's present with attorney Bruce Cobb. Attorney Cobb, what is your announcement regarding Ms. Stevens' case?
We're going to be trying.
You ready? Okay.
Yeah.
And state?
Thank you.
Okay. Next case is cause number M333414, case of style of state of Texas versus Jose Fernando Balderas. Mr. Balderas is present with his attorney. State, yeah, okay. State's ready on that one. And next case is cause number M331896, case of style of state of Texas versus Alexis Lajuan Green.
Thank you.
I don't believe she's present, Your Honor.
Is Ms. Green present?
I don't believe.
Would you
she's
please
present.
call the name of Alexis Green at the courthouse door?
Green and
No response, Your Honor.
Okay, Alexis Green did not answer. A reasonable time has passed to give Ms. Green an opportunity to appear in court. She was scheduled to be in court here at 1:30 for the court's trial docket. State, do you have a motion?
stay with Bob over.
That motion will be granted. Alexis Green bond will be forfeited and a warrant should be issued for arrest and cause number M331898. Next case is cause number M326856. Case is style of state of Texas versus Dwight Jermaine Lewis. Mr. Lewis is present with his attorney, Mr. Wright Kimmler. Attorney Kimmler, what's your announcement?
Ready.
Thanks, man.
State's ready, okay. Next case is cause number M331312. Case is style of state of Texas versus Haley Renee McCray. Ms. McCray is present with her attorney Wright Kimmler. Attorney Kimmler, what's your announcement?
Ready.
State's ready.
State's ready. And the next case is cause number M330825. Case is style of the state of Texas versus Xavier James Ozan. Xavier Ozan, is Mr. Ozan here?
Yes,
Okay. Mr. Ozan is present with his attorney Wright Kimmler. Attorney Kimmler, what's your announcement?
Ready.
State's ready.
State's ready, okay. Next case is cause number M327802. Case is style of the state of Texas versus John Trimble. Mr. Trimble is present with his attorney, Mr. Kimmler. Mr. Kimmler, what's your announcement?
Ready.
State's ready.
Next case is cause number M334138. Case is style of the state of Texas versus Donovan Heath Morrison.
Your Honor, he doesn't have a driver's license. He's about 10 minutes away. His ride picked him up a little bit late.
I think if he shows the state anticipates a bench trial, but he's gonna have to show.
And he will. He's been here every time. It's just he doesn't have a driver's license and his ride picked him up late. I just spoke to him on the phone and they're in trial.
It's fine.
Okay, so we'll hold off on that.
We'll hold our bomb drill on that.
Okay. 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 Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M334-138. Case is style of State of Texas versus Donovan Heath Morrison. Mr. Morrison, is that your full name?
Yes, sir.
Mr. Morrison, how are you doing?
Good. How are you, sir?
I'm doing fine. Thanks for asking. Ms. Morrison, you're here represented by your attorney, Attorney James Padgett. Attorney Padgett, how are you doing?
I'm doing well, Your Honor. Thank you.
State is represented in this case by Attorney Colby Hallfire. Attorney Hallfire, how are you doing?
Good, thank you.
Mr. Padgett, initially your client had requested a jury trial. Is your client waiving his right to a jury trial in this case?
Yes, Your Honor.
And state, you join in that waiver?
Yes, Your Honor.
Okay. Mr. Padgett, are you ready?
Defense is ready, Your Honor.
And state, are you ready?
Just 1 second, Judge. Let's take the information. We're ready.
Okay.
We ready?
All right, Judge. Say, Judge.
State, would you like to read the information?
Yes, Your Honor. Please, the court, cause number M334-138. Information in the name and by the authority of the state of Texas. I was now the undersigned assistant criminal district attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the county court at law of Jefferson County, Texas, that in Jefferson County, Texas, Donovan Heath Morrison, hereinafter styled the defendant, heretofore on or about February 10th, 2023, did then and there intentionally, knowingly, and recklessly cause bodily injury to another, namely Heather Nicole Long, hereinafter styled the complainant, by striking the complainant with his closed fist, and at the time of said assault, the complainant was a person with whom the defendant has had a dating relationship against the peace and dignity of the state, signed by assistant criminal district attorney.
Mr. Morrison, how do you plead?
Not guilty.
Not guilty? Okay. State,
We'll waive open, Judge.
you waive your opening statement, defense?
We'll waive, Your Honor.
Okay. State, would you like to call the first witness?
Yes, Your Honor. They calls Heather Nicole Long.
Heather Nicole Long.
No response, Your Honor.
For the court's record, Your Honor, the state has had contact with Ms. Long. She met with the DA's office. She took the options class, which is part of our protocol and assault and violence cases. She signed an affidavit of non-prosecution, and she met with my co-counsel, Ms. Erica Porter, yesterday on this particular case. She does not want to cooperate, therefore the state rests the case.
Okay. Mr. Padgett,
Defense moved for an instructed verdict and asked that the defendant be found not guilty, Your Honor.
that motion will be granted. Mr. Morrison, you have been acquitted of these charges. Your attorney will be given a copy of this judgment in a few minutes. Once you get a copy of the judgment, you'll be free to go, and you have a blessed day.
Thank you, Your Honor.
You're welcome. You're free to go as well.
Yes, Your Honor. Thank you.
They said Miss Green appeared. That's the lady we did the bond forfeiture on. Okay. What's the state's position?
We'll recall
You recalling the bond forfeiture?
it lawful.
Okay. Now, Miss Green, you appeared late. You didn't appear on time. Prior to you coming into the court, your bond was forfeited. However, the state has just made a motion to withdraw the bond forfeiture. So your bond is no longer forfeited, it's been reinstated. So if you have any court dates, you need to make sure that you appear on time. Do you understand? Okay. So at this time, we have Ms. LaSudden Stevens. Would you please come forward? Your case is set for trial. Green, M331898. M331898.
That's this point, is that your case?
Yes.
You can have a seat. Y'all can have a seat. Y'all announce ready, right?
Your Honor, I think before we bring the jury in, we have some housekeeping issues we need to discuss with the court on this Stephen case.
On Ms. Stevens' case?
Before
Okay,
we bring the jury in.
okay.
Do you want to release mine?
Well, we'll usually release them as soon as we start picking the jury. The court coordinator have to give you that date. They're not released now, but Ms. Stevens, you can come on up.
You want me to get the date before releasing? Or?
Well, you can't release them now because we hadn't started picking the jury.
Before.
Yeah, I mean, we can get a date from Trina. You can go back there.
How do you do that?
Mr. Cobb. Said there was some housekeeping measures.
There is, Judge. I think there was, I won't speak from the court, but there are two cases. She filed a motion to consolidate the trial of both at the same time. Now, we haven't got a response in regards to whether there's an objection to do that. So before we start picking a jury on both, we need to know if we've got an objection from Mr. Cobb and doing both the UCW and the deadly conduct.
Okay, this is, hold on a minute, let me get to it.
And we got to one vote the rule before we bring it.
Stevens, hold on a minute.
How do you feel about that, trying both of those cases at the same time?
Meaning, Mr. Cobb, if you need to talk to your client, you can talk to your client in private in the court, outside the presence of everyone else. You could do it in the jury room, or you could do it outside the courtroom.
Your Honor, I don't think we have an objection. I just wanted to ensure that she.
Can we go and do so you can?
Sure.
Yesterday.
That's another client. I don't know what he had told.
I don't know. Well, we'll find out.
Okay.
Your Honor, we have no objection.
Okay, Don, Mr. Cobb, did you get a copy of the motion to consolidate?
Yes, I did. They said that.
Okay, now. It was just filed on yesterday.
Right.
Okay, normally they're required to, that shouldn't follow no less than 30 days prior to the trial pursuant to Article 3.02 of the Texas Penal Code, and you're saying you have no objections?
We have no objections.
Okay,
We'll waive any objections to that. And also we agree with invoking the rule. I would have done that myself too, but
okay,
we're fine. The only thing that I might have a concern about is if we have a punishment phase applying for probation. You have to have a written,
You,
you need to follow the rules
and that's has to be done prior
prior to the
to
trial.
sitting the jury, so it needs to be done.
right, I'm gonna go ahead and write it up. So I'll just have to.
Okay, well.
It's not, yeah, it has to be done before, it's not.
Okay,
We're going to court for punishment anyway, so I guess I could do that.
you don't need to. Okay,
I think it's best practice.
okay,
File it.
yeah, you can
File
file,
it,
yeah,
post, and then go to
yeah.
court. That way
Yeah.
you're not limited
Okay, sure.
okay,
for everybody.
okay. All right, hold on. And soon as I start talking, Mr. Byron, I want you to go stand by that first chair on that first row behind the wall. And so that's where the first person is gonna sit. Right there. Yeah. Mr. Byron is gonna be there.
Okay.
Y'all just please come to that first row. First person is Miss Ford Beverly. You're gonna sit in that first chair. And Mr. Owens next to her, Miss Tran, Ms. Rito, Mr. Terrio, Reyes, and Williams.
Number 8.
Okay. No, it's just that first row is gonna be 7 through 14, starting with Paul Vincent. Paul Vincent? You got Paul Vincent? It's gonna, next to him is Mr. Smith, Ms. Connor, Mr. Ring, Ms. Nixon, Ms. Hooks, and Bo Buff. That's Bo Buff? Okay, she's in a wheelchair, she can just stay right there on the end. Yeah, she can go in front of that. Yeah, that's good. And the next row, all the way over there, just follow Mr. Ibarra.
Yes, sir.
That's Mr. Burnett, Ms. Locust, Ms. Joya, Hoya. Ms. Hoya, just please follow Ms. Locust.
15.
Mr. Moss, please follow Ms. Hoya. And Ms. Janice, follow Mr. Moss. And Ms. Footman, follow Ms. Janice. Okay.
I'll see you.
Okay, all the other defendants are excused. You excused. Y'all have a blessed day.
Yes, thank you.
Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this afternoon for inclusion on a criminal case. The criminal cases are divided into felonies or misdemeanors. Your felony cases are your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they are not serious. It just means that they're not serious. And when I use the term serious, I'm talking about the facts of the case as well as the possible punishment that a person can receive if they are convicted of the offense. Now, you will be examined for inclusion on this jury. Our courtroom hours are normally from 9 to 5. However, here in County Court at Law Number 2, we usually have Lloyd's dockets. So in the morning, when we start at 9 o'clock, it is not unusual for us to go past 12 o'clock. And so what we normally do when we have jury trials, we start our jury trials at 1:30 in the afternoon, and then we will always start back at 1:30. So once we finish today, whoever is picked on the jury, we'll be asking for you to come back. If we're not finished today, we'll be asking you to come back at 1:30 on tomorrow. Whether you are selected as a juror today or not, you are performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate for recess, for meals, and at night. Now, I have to administer the first of two administrative duties, and the administrative duties is to administer the oath to you. So at this time, I would like to have each and every one of you to raise your right hand. And after I'm finished administering the oath, please say, "I do." Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service and qualifications as a juror, so help you God? Okay, you may put your hand down. The law requires that each of you must possess certain qualifications before you can be considered to serve as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover that fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, the way I'm going to ask the questions, I will ask a series of questions. I do not want you to answer out loud. I just want you to answer to yourself. And once I finish asking the last question in the series, I will then ask you, is anyone disqualified under the law? Now, if you think that you may be disqualified under the law based on how you answered the question, one or more of the questions, then I will simply ask you to raise your hand, and then we would ask that you will come up to the bench so we could discuss the matter more privately. And when I use the term more privately, what I'm talking about is this. Currently we on YouTube, we'll turn YouTube off, we'll turn the mic off, and then we'll put a noise sound device that sounds like this on. And then we'll discuss the matter. Now, once we finish discussing the matter, then we'll move on to the next series of questions. Okay, so again, I'm gonna ask a series of questions, need you to answer them to yourself. And once I finish asking the last question, I would then ask, is anyone disqualified under the law? If you think that you are, I'm gonna ask you to raise your hand. And then we'll, depending on how many people raise their hand, we're gonna call you up one at a time to discuss the matter more privately. Okay, so the first question, Except for failure to register, are you a qualified voter in Jefferson County and in the state of Texas under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this next question, I always pause and explain to you. The reason why I have to ask this question is by law, we have to ask the question. I'm not trying to pry into your personal affairs. But the next question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? That was the last question. Now, is anyone disqualified under the law? If you think you may be disqualified under the law, please raise your right hand. Okay, we have one person. All right. So at this time, Ms. Tran, we're gonna ask Ms. Tran to come up before the bench. Yes, she can come around. We have the lawyers and the court reporter to come up. Turn this off. Okay, I will now determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these exemptions apply to you, but you still desire to be considered as a juror, you will just continue to be seated. And I will ask the questions in the same manner that I asked the series of questions when I was trying to determine whether or not you were qualified. And so we will ask a series of questions. And once I finish asking the series of questions, after asking the last question, I will then ask if there's anyone here who would like to claim an exemption. First question. Are you over 70 years of age? Actually, the law has changed now. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 and your jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Or are you a person enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petit juror in Jefferson County during the past 3 years from today? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from Jefferson County and out of this county, which is your county of residence? Now, if any of these exemptions apply to you, just simply raise your hand. Okay, we have one person. Juror number 18, Thomas Andrew Moss, is that correct? Mr. Moss, would you please come forward? Ladies and gentlemen, now we will move to excuses. And the way we will do the excuses, I'll just state what the excuses are. And if you feel that there's a reason you cannot sit as a juror, we will ask you to come up before the bench so we can discuss the matter more privately. A juror may be excused for observance of a religious holiday upon the completion of an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the state and without the consent of the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Now, is there anyone here who will be claiming an excuse or exercising an excuse? Just please raise your right hand. We have one gentleman. Okay, that's juror number 6. Adam Reyes, is that correct?
Yes, sir.
Mr. Reyes, would you please come forward? The court is back in session and calls number M332610 and calls number M332608. Both cases are styled the state of Texas versus La Sudden Surprise Stevens. Let the record reflect that no one has claimed an excuse, and there was one exemption, one person who was not qualified, and so therefore the jury panel is qualified. Ladies and gentlemen of the panel, the case before us is styled the state of Texas versus La Sudden Surprise Stevens. Now, Ms. Stevens is sitting in before me next to her attorney, who is Mr. Bruce Cobb. The state is represented in this case by attorney Erica Porter, Assistant District Attorney, and Assistant District Attorney Kobe Hoffbach.
Good afternoon.
The court reporter in this case is Miss Ada Christie. She will be taking down everything that is being said. So when you are answering or asking questions, please speak up so that she'll be able to hear you. Now, in this case, we have three bailiffs. We have Deputy Martin, Deputy Ibarra, who's sitting over there, and behind you, we have Deputy Woodle. Now, Miss Stevens has two cases. These two cases have been consolidated, which means they was joined together, made into one. One case is deadly conduct, and the second case is unlawfully carrying a weapon. All of these cases occurred in the same, what we call the same criminal episode, out of the same dates and facts. If convicted, both of these cases are classified as Class A misdemeanors. If convicted, Ms. Stevens can be given punishment of anywhere from 0 days to 365 days in county jail. She could be given a fine from $0 to $4,000, or she could be given both fine and confinement in each case. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the other members of the panel, just say so, and I will speak to you more privately outside the presence of the other jurors. And when I say more privately, we'll turn on the sound device and we'll turn off the microphone and the YouTube. Is the state ready?
Thanks for having me on.
Is the defense ready? Ms. Porter, the panel is yours, and we'll give each side 30 minutes.
My name is Erica Porter, and I represent the state of Texas, along with my partner here, Kobe Hoffbach. I'm going to be behind this podium for a few of my questions, and then I'm going to kind of walk in front of you guys and ask you questions, so I can get to know you a little bit better. And that's necessary because I want to make sure that you're a good candidate for this year. Okay? So the more you talk, the better it is. If you're silent, I have nothing to do. I mean, you're probably gonna get picked on. So if you want to talk, want to get out here, talk to me. Okay, I'm gonna be calling you out individually in just a few minutes. We're gonna start out with deadly conduct. Comes from Texas Penal Code 22.05. And you can look at the TV screens on the side of me. If a person commits an offense, if the person is coming up slow, recklessly engages in conduct that places another in imminent danger of serious bodily injury, Now, we can presume that someone was reckless and there was danger if the actor knowingly pointed a firearm at or in the direction of another. Whether or not the actor believed the firearm to be loaded or not, it's just presumed. Okay, so the defendant, this is what we have to prove the state. On or about a certain day in Jefferson County, that's this county, did recklessly engage in conduct placing another in imminent danger of serious bodily injury. Those are the elements. First charge. Recklessness and danger. Again, it's presumed that the actor if the actor knowingly pointed a firearm at or in the direction of another person, whether or not the actor believed the firearm to be loaded or not, then that person acted reckless. Reasonable doubt. I'm gonna talk a little bit about reasonable doubt. I'm gonna kind of skate in front of you. Well, become a little bit more personal. Now, Texas law requires that the state, which is me, represent the state of Texas. My boss is Keith Gibbons. It requires that we make our case. We bring the case and we have to prove it. He doesn't have to prove anything. He's the defendant, okay? So I have to bring in all the evidence and proof beyond a reasonable doubt. Now, it doesn't mean beyond all doubt. Okay, so there might be some scintilla of doubt there, but it has to be reasonable. And this kind of vague definition, because it leaves it up for interpretation for you, right? So you have to determine what is enough. What is enough? And you'll know because it's common sense. You'll know. Best way to explain it, you'll know it when you see it. Trust your instincts. What's an example of reasonable doubt? Somebody. It's time for you to talk. I'm gonna get a little random here. You're back in school. You're back in school, so I'm gonna ask Crystal. What is an example of reasonable doubt? Tell me. Think about it for a second. Somebody want to know? You're still in the hot seat. Anybody want to?
I don't know, percentages?
Well, just give me an example of what you would consider reasonable doubt. If you know. Just write on. Okay. Do you need someone?
Okay, I got it.
Anybody? Okay, go ahead.
Something you think a reasonable person might do in that situation.
Okay, so what's this Alan on? What do you think? I mean, give me a situation.
Like we're talking about here, point a gun. A reasonable person wouldn't point a gun at somebody that's really needed to do something. It's not a very safe thing to do.
Okay. What would be the amount of doubt that you need to see in order to say, oh no?
That she might have a reason to do it.
Anybody else want to expound on that? Anybody? Talk to me, Mr. Williams, Joseph.
Based on, anything for, show any type of force for another individual, I was assuming that they might have for a reason.
If the witness was uncredible.
Okay, credibility, and who determines credibility?
If the witness was partial towards the lady, then we can't trust their testimony.
Okay, and who would make that determination?
Just common sense.
Okay, and who would use their common sense in this situation? Okay, you know, correct. Okay, now I'll get a gold star. That's a good, that's very good. Okay. Conflict in testimony does not create reasonable doubt. So what about minor details? There's some minor details. Oh no, the button on the shirt was red. Was that enough to create reasonable doubt? No.
Some people have more attention to detail than others.
Right, and as time passes along, sometimes memories get a little foggy. Is that right? Okay. One witness room. Texas law does not require a particular number of witnesses. Texas law requires that the state prove their case beyond all reasonable doubt. Y'all agree with that? Anybody doesn't agree with that? Okay, so who thinks, raise your hand if you think that's a good rule. You do.
Yeah. I mean, you gotta have more than 50% that you think that person committed that.
Right, okay, so you're saying that that's the bar, it
Scale
has to be more than 50%.
But sometimes there's crime and there are 0 witnesses, but it doesn't mean they can't be prosecuted.
So what else would you be looking at? If there was
Evidence, DNA,
very good.
statements by the defendant.
And you are Ms. Connor, right? Okay. All right, let's see. We talked about the one witness rule. Who decides where the crime occurs? Who decides this Katrina? Okay, who decides where that crime occurs? When there's a crime, who decides where it occurs?
The person that's committing the crime.
Bingo, and Ms. Hoya. Let me make sure I pronounce your name correct. Ms. Hoya, we're gonna ask you the second question. Who decides when the crime occurs?
The person who committed the crime.
Correct. Okay, good. Who decides how many people the crime occurs in front of? Gonna ask Ms. Langford.
I guess the person committing the crime.
Very good, very good. Y'all, all our answers are good. I'm not gonna say that. Very good responses. In fact, it's what we expect in most violent crimes, right? The individual committing the crime decides it. Texas law does not require a particular number of witnesses just overkill. I'm just going through it once again. We have a one witness rule. Credibility, let's talk a little bit about that. It came up. I can't remember who brought it up. With credibility of witnesses. Tell me, Mr. Owen, who decides who's credible, a credible witness? What would you look at in the time?
The way they answer the questions or I guess the quickness where they answer the question.
Okay. Okay, what about you, Ms. Ford?
The person that's present also at the time of the crime.
Okay, so was it an eyewitness you're saying? Yes. Okay. All right. What they say, what about how they say it? I think you said how they answer the question. What they say in particular, I'll agree with that, what they say. Okay, Mr. Smith, why they say it? What am I talking about when I say why they say it?
And especially what would they gain, what was their relationship with the.
Okay. Anybody else have, that's, anybody else have anything to add?
Maybe if they fear for their safety, if they know that person's, something doesn't happen to them, will there be repercussions on them?
So what they say, does it make sense? What to believe? All of the testimony, some of the testimony, and none of the testimony. Who determines what to believe? All of the testimony, some or none of the testimony? Okay. Common sense, like pieces of a puzzle. Presumption of innocence do you believe that there is a presumption of innocence? Yeah. Do you believe in the presumption of innocence? Yeah. Think it's important? Yeah. Tell me why you think it's important, Miss. And I can bob it up, both.
Because you have to prove she's not. So we assume when she comes into court, she is innocent. And if you prove different.
So right now, if I asked you to vote.
Yeah. No one's proven anything.
What am I doing?
I mean, everybody's innocent to an extent, but I mean, there is laws that come to play.
So right now, have I presented any evidence against her? So if you had to vote right now, what would you vote? Everybody believe that? Anybody believe she'd be guilty at this point?
No.
Okay, because I haven't met my burden. Right. Everybody has, it means the state has to prove defendant guilty beyond a reasonable doubt. What does the defendant have to do? Nothing. She doesn't have a burden. Okay? It's on me. So I have to prove my case. Subpoena power, she can subpoena if she wants to. They can subpoena. Right to discovery, they get everything. Everything that I have, they have access to. Right to a trial, that's why we're here today. Right not to testify? She have to testify. Let's talk about that. Ms. Footman, do you think that is fair? The defense doesn't have to testify. She doesn't have to get up there if she doesn't want to. How do you feel about that?
That's fair.
Why?
This is their right, their choice.
Okay, so
wants to speak on
now let me take it a little step further. Okay, so if she doesn't testify, is there any inclination that she's guilty by anybody in here?
No.
So what, give me a reason why you think she wouldn't, so someone wouldn't testify.
Get nervous on the stand.
Okay. All right, Stacy.
Somebody turn those lights off.
Okay. It's a little blurry. So, yes, some people do get that. Is anything, another reason why someone would want to testify? Miss Melanie. Last name, Terrio. You, tell me why someone wouldn't want to testify. Okay, anything else come to mind? And why? Okay, go back to your burden. Okay, there's something you said there. And what's that?
They didn't think you proved the case.
And also, I heard that, because they're nervous, and they just come up with, you know, things that they shouldn't come up with.
Okay. Right to exculpatory evidence and right to defenses. So they have a lot of rights as defense. As defendant, okay? Defense has a lot of rights. They don't have to prove anything, it's all on. Anything I have, anything that could benefit her, exculpatory, I have to give it to her. It could be anything that could benefit, actually something that could actually benefit her case. That's out there moving in the abyss, and I know that I can't keep it from her, so she can't have an extra reality. I can't do that. I have to do. Okay, and that's what I'll do. If I had something, I would. Okay, so jury's duty. Decide the facts. Who decides the facts? Absolutely. Apply the facts to the law and follow the law. Who has had a firearm pointed at them before or even displayed? Okay, hold on, let me start on this end. Okay, tell me about your situation. Ms. Brady.
I had someone steal my car here, 30 years ago, when they wanted to.
Okay, did they get your car?
Yes, it is, because I gave it up.
Okay. Okay, and you, what happened in that situation? What was the resolution? Were charges filed?
Filed, and he was convicted once, and the refile was, the charges were dropped, or whatever he was in.
Okay, were you satisfied with that
Um,
resolution?
it's not bothered, I mean. Yeah,
Yeah, okay. Anyone else? Can you talk to me, Mr. William?
I'm a volunteer firefighter in one of our calls is a medical work button. Older of the person fallen. And we couldn't make entrance to the house. So go ahead and advise us to make entrance through the nature. So we made entrance, and the patient was not mentally coherent and happened to have a firearm. Pointed at me as I made entrance. We were able to settle the situation. And transport.
Right. Were you afraid at that moment when the firearm was pointed at you?
We have protocols, but you kind of move. But
Were you, I'm sorry. Were you afraid?
No, not in the town.
Anyone else?
Way back when I was in high school, my neighbor, told me he had a place to duck hunt across the river in Fort Natchez. I went duck hunting with him, and come find out it wasn't one of his places, and the guy that really owned that lease. And they didn't shoot us, so
How did they make you feel with it?
I didn't know 12 gauge had a barrel. That's scary.
Okay. Did it put any fear in at the time?
Yeah.
Anyone else?
What's your definition of display before you?
I would say if it was not pointing at you, then maybe it was showing.
Okay, no, it's like, hey, look, good.
No, display was considered, so
Okay, yeah.
anything like that. Anyone else want to add in? Okay. Example of evidence that may show victim was threatened with a gun. So what would you want to see in this trial? Tell me now, what would you want to see? Evidence. What? Video. What video?
Depending on where the location is.
Okay, so if there was the right, okay, video. Is anyone else? Okay, so that's
Yeah.
I'm witness.
photograph. Photograph. Photograph of what?
A picture of the actual thing happened.
Okay.
And there's a lot of these around.
They made it pretty easy to capture things, right? Okay, all right. So now we're gonna get into unlawfully carrying a weapon. Disorderly conduct. So you still have disorderly conduct at the top. We're talking about unlawfully carrying a weapon. So what comes to mind when I mention that unlawfully carrying a weapon? We're gonna expound upon it a little bit. A person commits an offense. If the person is engaged in criminal activity other than a Class C misdemeanor, that's in violation of law or ordinance regulating traffic and boating. So if he has or she has a weapon on their body, their person, when they're committing another crime, they can get charged with this. So. Y'all understand that?
Well, thank you, Your Honor, I'm gonna say that disorderly conduct is an extreme offense as opposed to this, being what.
Mr. Okay, what's your objection?
My objection is that this, any discussion of disorderly conduct is, if it's not used as a hypothetical, I would object to it as an extraneous conduct. She's not accused of that.
No,
She's accused of deadly conduct and unlawful carrying.
Okay,
Right,
what's your response?
She's only accused of those two. That's why I said omit that at the top. The disorderly conduct tab was not supposed to have been.
Okay, your objection is sustained.
Example of evidence that may show an individual committed the offense of unlawfully carrying a weapon. Okay, so what would be an offense, just comes to your mind, of an individual who is charged with unlawfully carrying a weapon?
Carrying a weapon in public without a CHO.
Okay, so what offense would he or she? Okay. Okay, so what offense, in this situation, the person who's committed the crime, how would you be able to attach that on? What are you thinking? If they had a weapon as well? When they were committing the crime, what crime? It could be any crime. So an example would be if a person was what? In the store, committed, armed robbery, theft, and committed a crime and had a weapon on this. Those things, okay? Just think along that line. Do you understand?
Everyone has a right to carry a firearm. We all have the right to bear arms, do we not?
Yes, but I'm not gonna go down that rabbit hole, but you are absolutely right. We do have a right to carry a firearm. There are actually rules that are associated with that. You're right.
But in some places you can have.
Correct. You're right. Prior jury experience. So I was able to take some notes. A lot of you had civil jury experience. Some of you had criminal and grand jury. Paul Benson, you have grand jury experience, right?
Yes, you get to see the whole show.
You didn't see the whole show, you enjoyed that?
It was very interesting.
Okay. And Robert Ring?
Yes.
You had criminal jury experience, right?
Harris County. So,
Okay, you don't need to burn?
Yes.
You don't assess punishment as well?
Yes.
Adeline Nixon, criminal, okay, so. Oh, molestation, and the John Giovanni. You don't assess punishment as well? You did, okay. James Barnett,
Yes, ma'am.
yeah, criminal,
Yes, ma'am.
did you reach your verdict?
It was great.
It was great, oh, and it was in Jefferson County,
Yes, ma'am.
did you assess punishment as well?
I can't remember that. It's been so long, my mind's getting old. It's been many, many years ago.
Katrina Jennings, yeah. Did you reach the verdict in your case, which criminal, it was here, it was here. Yeah, it assess punishment as well. We did. So civil, I have Miss Ford, Beverly, and I think Paul Owen, so you. Several. Have a couple more, so Mary Landcross and Katrina Jennings. So you know what the jury experience is all about, it's a little different from criminal and civil. You did serve on jury. Grand jury as well. Oh, grand jury. Okay. Anyone know the defendant or the defendant's attorney? Anyone know me? No, I'm a partner. No, okay. Does anyone know the judge? I can even ask, you know, Judge Holmes? No. You know Judge Holmes? How do you know Judge Holmes?
Hey, definitely with some legal and, secretary, wills that I had experimented there
Oh, in the past, he didn't.
in the past.
Okay. Anyone else? Anyone can't sit in the seat of judgment. Anyone for religious reasons or any reason at all, they feel like they just cannot sit in the seat of judgment of others. Now's the time to raise your hand. Any questions for me? Thank you.
Mr. Powell, you may proceed.
Good afternoon, folks. I'm sorry, I didn't, I hope I didn't speak if I didn't say much, but that's something I was looking at, and I apologize for that. This is the first time I get to meet you. I'm Bruce Cobb. I do defend these cases. I do take criminal appointments, and today I'm defending this what's surprise Stevens. If I might ask you again, does anybody know me for sure? Take a pretty good look at me or something. Maybe some of the men, I don't know, have any of you ever served in the Army Reserve, the National Guard? Army Reserve, National Guard, I take it by silence that there's nobody like that. I might have run into by accident and said, I remember this guy. I was active in the Army Reserve for a time. And, you know, I just want to make sure there's nobody here that they don't recognize me from a long time back. That was a while ago. The prosecution did talk about presumption of innocence. I'm not going to go ahead and do a whole lot on it, but as you understand, Ms. Stevens is presumed innocent until she'll prove guilty. But I would like to go ahead and talk about beyond reasonable doubt action. What I think. You know, I think one of you, I think Mr. Ring talked about percentage. Sometimes that's a nice way of being able to look at it. In a civil case, you have preponderance of the evidence, which is 51%. So if you are able to prove your case, quality of evidence, of course, you got the quality and the quantity together. That evidence convinces you, hey, I believe whatever they said, like for example, the wreck case. you believe that, the defendant in that case was, negligent because of car wreck. 51% of that evidence would be supporting a verdict for, the car wreck damages by preponderance of the evidence. Now, there's another standard. We're getting toward reasonable doubt, but there's something called clear and convincing evidence. So if we take that scale and move it a little bit further, like 75%, I think y'all who know percentages would agree that that makes it a lot more understandable. Clear and convincing evidence is rarely used. If we had a case where we were terminating someone's parental rights, we would use clear and convincing evidence. Or we're going to put somebody in a mental health institution for a long time, we would have to have clear and convincing evidence. The person was a danger to himself and others. That's 75%. We're going up the scale a little bit more. So it's not absolute certainty, not 100%, definitely that. So we move it back down. We get this case beyond a reasonable doubt. Beyond a reasonable doubt, or, little words that make a lot of difference. It's not all doubt, but it has to be beyond a reasonable doubt. Now, they talk about what a reasonable doubt would be. Let's say you see something in the evidence, and you think that's not right. And you think more and more, and it sort of nags at you. It won't go away. Well, that may be a good example of what a reasonable doubt is. Credibility. You look at the way somebody's talking to you, somebody testifies, the circumstances, do we have circumstances where people are talking a little bit too fast, or this doesn't quite look like, maybe this person looks a little shady. We all know what shady person looks like and stuff like that. And you can't quite believe what this person says because of the circumstances. So that in itself might create a reasonable doubt. If in feeling in your gut, hey, this isn't right, that could be a reasonable doubt. The prosecution must show that all the elements were done beyond a reasonable doubt. In this case, and they talked about the one witness rule and all that, could you prove a case with one witness? Yes, but that witness has to be credible. Very credible. Because that's a high standard. That's a lot of matter. And it has a great effect on the defendant. You take a person's liberty away, you're going to send them to jail. They're going to have a hard time trying to get a job. There are all kinds of consequences that happen because of a criminal conviction. So that's a very important concept. We're going to be talking to some witnesses, some police officers. Police officers usually have a very busy job to do. But sometimes, when you come after the fact, you're basically there after it's already happened. You have to make decisions. You have to try to at least sometimes act in a way that protects the public. And sometimes these actions don't necessarily mean that the person is guilty, but it is, they're doing their job of what they have to do. That doesn't mean that you have to believe them, or you can believe them and say, hey, I don't think they really know. I don't think they really know. That's not totally believable. I still think I have a doubt about whether or not so and so is guilty. And sometimes that happens. We talk about deadly conduct. One thing about deadly conduct is, like, for example, if you point a gun, that can be presumed deadly conduct. We don't disagree with that. If there's a question of Joe Blow says, hey, he pointed a gun at me, and then she says, no, I didn't point a gun, we have a fact issue. We could have, East Texas swearing match. And you have to believe who is credible. That puts it in a very, very line. What other circumstances could you believe that that person who's testifying and says, yeah, he pointed a gun, be more credible? Or what if there are circumstances that show that person is not still credible for one reason or another, which there could be in this case? So you have to look at all of the circumstances in this case, find out whether or not beyond reasonable doubt you believe that so-and-so pointed a gun. One thing that I'm not really clear about and certain is whether or not just displaying a gun is the same as deadly conduct. Okay.
Can we approach him?
Yes.
What's the, yeah, the objection?
Not the law, your honor. The law is exactly what's read. If he disagrees with the law, it's fine.
Hold on a minute.
Well, I'm not necessarily disagreeing.
Oh, whatever, yeah, sure. Okay, objection is sustained. Mr. Cobb, you can, restate the law.
If, I'll just go ahead and say this, if the court gives you an instruction on deadly conduct, would you all agree to follow it? I don't think there's any problem with it. I'll put it pretty much that way. Let me go into something else, traveling. Calling again the unlawful carrying. offense of which she's accused of. But the second offense, are you all aware that the law allows you?
We're checking, Your Honor. I think we did approach again before we get into the law.
Okay. Well, y'all can do it from there. She doesn't have to come up here.
It does.
Right,
Your Honor, that's not, the law has changed and the traveling exception and with the council, before we get into it, we want to make sure we're clear, we're not giving old law to what's current at this point. So to confuse anybody about what the law is,
Okay.
and which is very important in this case, I mean.
okay.
Oh, hold on a minute. Now, the charge is not just unlawful carrying a weapon, it's unlawful carrying a weapon while engaging in criminal activity. Okay, I think
We're gonna
you were raising a travel defense.
Right,
an affirmative defense, correct?
that's it.
That's,
It's a defense. It's not a affirmative defense, or it used to be.
that's what the state is concerned. I think we're adding confusing and this argument at this point.
Well, I mean, at this point, the court we will sustain your objection. Now, the court is going to give the jury a charge, and in the charge, it will contain the law
Right,
and any defenses that may be applicable to this case.
right. Okay,
Thank you, Judge.
sure. How many of y'all are parents? That's pretty much a lot of the jury. I don't know, there's so many of you guys, I don't know if I could ask each one of you, whether or not, was anybody having children that are 8 or 9 years old? Children, you have children, Mr. Ray? Okay. Anybody else has children? Okay, I think, have children that's 8 or 9 years old. That's a very good age. Or younger than 8 or 9. Anybody have children younger than 8 or 9? Okay, me too. We're still pretty much in the fatherhood age.
I'm 5 weeks.
Wow, congratulations.
My oldest is 14, so I'm a newborn in high school.
That's quite a contrast. And if a child, say, is, what are your thoughts about a child being a witness, 8 or 9 years old? Does that seem to make it more credible to you, or does anybody feel it's less credible? So a 9-year-old would not be a credible witness in the case. Yes, you have to know something about the child. Okay. Well, what would you ask? You would ask, background questions more to establish credibility, or you think you would want to observe the child? That's what.
Well, like if the child is her child, or if the child just happens to be by, or the circumstances of why that child is in that situation.
Right. You want to consider all of that. Anybody else? Anybody else?
If the child understands.
Right, which goes right and wrong, definitely, definitely. Do you believe that children at that age are old enough to understand? Sure.
Yeah.
Okay. Anybody else feel the same way?
And also depends on the child's background, how the child grew up. If they had a rough growing up, versus, growing up, it will color their framework, how they do life.
Right. Yes, ma'am.
It also depends if the child had a cell phone in the hand at the time, because if they did, I would think they're not even paying attention to what's going on around them.
Okay. Anybody else?
I'm just gonna say, I teach 3rd grade, so I'm with 63, 8, 9-year-olds all day long, and they don't always are aware of what they're saying, and of course, their background lends itself to what they know and.
Could that child tell the truth anyway?
Yes.
Yes, ma'am. Yeah. Right. Let me just ask you a couple, is there anyone here that has relatives in law enforcement? Okay. Anybody else secure? Your spouse or?
Family.
Questions a little bit. Do you have any relative in law enforcement? I just asked that, I mean, any relative that's in trouble. What you have been in trouble. You're- Is that furthers the problem on that so
He was in front. The judge went there and he did his probation. And got his act together.
that's fine. You believe people on probation can get their act together?
Huh?
You believe that people who do get probation can get their act together?
Yes,
Yes.
yes, but, you know, and it just depends on who they want to hang around with.
Right, right.
You know, if you hang around with the guy that's not good, they're gonna be influenced. And my son learned.
Right, I understand. That's all the questions I have. I do thank you for your time. And thank you for, I appreciate that.
Okay, ladies and gentlemen of the panel. You're going to follow the bailiff into the hallway. And while you're in the hallway, we may call some of you back in to ask some follow-up questions. So at this time, the court will be in recess. You can stand and follow the bailiff in the back. Hey, do y'all have any
We don't have anybody, Paul.
defense? You have anybody?
We don't have anybody in the fall.
Okay, so at this time, okay, we'll be in recess to give you opportunity to make your strikes. And once we need about 5-10 minutes, how much? 10 minutes, we need each side 10 minutes, and once you make your strikes, you'll bring them into the office. Okay.
We make it on the